Hi there. Good morning, everybody, and welcome to our second webinar. And the specific topic, subject matter will be on registered charities for advocacy. And we have a very special resource person for this session from the Eiler Campbell Law Office, and her name is Lauren Bluma. So let me just say a few words on Lauren, and then I'll try to put into context this particular conversation in the broader framework of the course. Okay. So Lauren is a lawyer with, as I said, the Eiler Campbell Law Office. She has an amazing, diverse practice advising charities, nonprofits, co-ops, and social purpose enterprises on a number of corporate and member issues. Lauren is building a practice in elder law and has a particular passion for working with clients as they navigate the intricacies of aging member and tenant populations. That's quite a mouthful, and very useful, very relevant to this conversation. So, where is this particular session located within the broader context of the social justice course? I guess that's what you may be interested in asking at the beginning. Well, let me bring you back to the framework we have been using. That social analysis involves two kind of contending, uh, what do you call this, points. One is its analysis should be complemented by action, and action should also lead us back to analysis. I'm sure you dream about that and talk about that every time. So that's one pair of two polarities, two tension points, and they need each other, analysis and action. Then the other pair, two essential points, is that social analysis involves self-reflection. We try to deepen our self-awareness to understand ourselves, our interests, our location. And for that purpose, we use the power petal in terms of understanding ourselves from different locations. Opposite that point is a greater understanding of our social realities, things that are outside of ourselves. And the example of that we did is understanding structures. If you remember the Columbus picture, structures have historical roots. So by structure we mean systems, institutions, policies, whether it's economic, social, political. And that's where this particular session belongs. So to help us understand one element of that broader set of social realities, we are going to focus on the possibilities and the constraints of the law as it pertains to registered charities. What can you do to educate, to organize, to mobilize, so that you are actually not violating the law at the very least? But it's actually more than the don'ts. It's also what can be done within the law. So, understanding the registered charities legal framework is a tool so we can maximize the space to do what we have to do. I hope that fits in with Lauren's presentation. But essentially, that's how it fits in with our framework. We are slowly, one by one, taking a look at different systems and institutions and programs that impact our work. And one of them is, as I said, uh, the policy legal framework pertaining to registered charities and their advocacy. So please welcome Lauren and have a great conversation.
Thank you. That was a great introduction to what we're going to be talking about today. Today we're going to get a little bit more into the nitty-gritty of from the legal perspective of what type of activities charitable organizations can undertake and what kind of advocacy you can undertake in that context. So again, my name is Lauren. I know that some of you might have questions throughout, and usually I'd take them as they come. I kind of like how that conversation sort of unravels, but because of the technical limitations here, I think it makes most sense to hold your questions to the end. You can write them in, and we'll just address them all at the end. So feel free to write them as they come to you, but just know that we'll be getting to those in a little while. Oh. Okay, so we'll start with the guiding principle here. I'm just going to read you a little quote from the CRA's policy statement on political activities, which is really sort of the guiding policy on political activities undertaken by charities. So through their dedicated delivery of essential programs, many charities have acquired a wealth of knowledge about how government policies affect people's lives. Charities are well placed to study, assess, and comment on those government policies. Canadians benefit from the efforts of charities and the practical, innovative way they use to resolve complex issues related to delivering social services. Beyond service delivery, their expertise is also a vital source of information for governments to help guide policy decisions. It is therefore essential that charities continue to offer their direct knowledge of social issues to public policy debates. So I wanted to start with that quote just so that we understand that it's charities are really well placed to inform and give feedback on public policy as frontline service, as delivering frontline services. With that being sort of the guiding principle that, in fact, yes, they are well placed to give feedback. It has to be within the legal framework and considering the constraints that the Income Tax Act and the CRA imposes on how that's done. There are. I just want to start by saying, if when we get into what a charity can and can't undertake, when we're sort of talking about being on-side and off-side of the CRO rules, the charities need to keep in mind that there's very serious consequences for finding yourself off-side of those rules, which can result up to revocation of a charitable status. So that's the consequence of being offside the rules, and that's what everybody is concerned about. But there's a lot of space. There's a lot of space in between, which allows for advocacy and political activities to take place. So our goals today are to know what it means to stay on side of the CRA rules. We're going to talk about the relationship between charitable purposes, charitable activities, and political activities. So what are those things? I understand that we're talking to a mixed group here today of with various backgrounds. So we're going to start with the basics. What are political activities? We're going to sort of tease that out. What types of political activities are permitted, and special rules that apply to political activities. So that's just a quick overview of how we're going to go about it. We need to spend any time really on that. Okay, so let's dive right into the basics. So the purposes of a charitable organization, and you're going to hear me refer to this often throughout, so I wanted just to distill what that means. It's the objectives of an organization is created to achieve. So this is what's actually found in the organizing documents called letters patent of a charitable organization. So the some of you might prefer to think of this as the objective or the mission. Maybe those words work better for sort of thinking about what the purpose is. So you'll recall that a charity must be organized for exclusively charitable purposes, or charitable mission, as you prefer. There's only 4 categories of charitable purposes recognized in the law. So you'll see there's the 4 categories: relief of poverty, education, religion, and other purposes beneficial to the community. Those are the only charitable purposes recognized at law, and so a mission must fall under one of those general headings. Other purposes beneficial to the community is determined by the courts, and it requires that there be a tangible benefit to the public. So, for example, organizations that promote racial equality through positive race relations would fall under this sort of 4th other purposes beneficial to the community. A lot of also refugee and immigrant settlement services fall under this 4th category. So other purposes beneficial to the community, you might be wondering, why can't that purpose be political in nature? So can the mission of the charity be political in and of itself? And the answer is no, it can't. And the reason comes out of an old case from the UK, Bowman and the Secular Society. You'll see way back in 1917. The reason is because political objects or purposes or mission have always been held to be invalid, because the court has no means of judging whether proposing the change in the law will or will not be for the benefit of the public. So that being that there always has to be a public benefit element, and courts don't have the tools to judge whether a particular change in the law, for example, would be beneficial to the public. They only have the tools for interpreting the law as it is. So that's the reason why we can't have a political mission. So as for activities, so that's what we're really going to be talking mostly about today, are activities and political activities and advocacy. In fact, they're not defined under the Income Tax Act. It's been defined by the courts, and you can think about it as activities as being what the organization does on a day-to-day basis to achieve its ultimate mission. So you can think of it as the specific programs that a charity undertakes. The CRA looks at in the context of determining what type of political activities are allowable. There being sort of 3 broad categories of activities that a charity may or may not undertake. So first we have prohibited activities, and the percentages beside there I'll explain it later on, but just for now you can just note that they're there. The second category being charitable activities, so those activities that go towards furthering a organization's mission. So a quick example, providing settlement services to immigrants and refugees might be the mission of the charity, and an activity charitable activity might be providing language training programs, and that would include all activities that go towards developing that language program, training of staff, whatnot. So everything that goes towards that. And a third category are political activities, and you'll see that it says 10% maybe beside it. And again, we'll get to what that means shortly. So first, let's get prohibited activities out of the way. This is what a lot of people concern themselves with. So 0% means that 0 of the charities' resources can be devoted to prohibited activities. So first and foremost, which actually is not one of the bullet points up here, but I think it's sort of intuitive, that a charity cannot expend any of its resources, so financial or otherwise, on activities that are not related to its purpose. The second, and which is relevant to our conversation today, is that a charity cannot undertake partisan political activity. So the CRA defines what is partisan pretty broadly. It's defined as any activity cannot directly or indirectly support or oppose any political candidate or party, Canadian or otherwise. So that sounds all-encompassing, and it is. It's really about linkages to a political party or political candidate. So this would include, for example, examples of partisan political activity which is prohibited would be, for example, providing financial aid or any other resources, for example, supplying volunteers to a party or candidate, making public statements that endorse or denounce a party or candidate, criticizing or praising the performance of any party or public candidate. So, for example, you can't come out with praising the performance of Tom Mulcair, for example. Slightly less obviously, but still falling under the rubric of partisan activity, would be organizing, for example, an all-candidate meeting in a way that favors a particular candidate. So, for example, you might invite, and this would be a permissible activity, you might invite all candidates to speak on a particular issue as part of a public awareness campaign. However, all candidates would need to be invited and all given an equal time to speak at the event, so as to not favor a particular party or political candidate. Of course, any illegal activity is prohibited. So the bottom line here is really that you need to stay away from any linkages to any party or candidate. Now, this does not restrict in any way workers in making personal representations about their partisan political views, so long as it's not suggested that it's also the charity's view. So this is where I think social media can come into play. You want to make sure that your organization has a policy, or everyone's on the same page, at least with any representations that are being made on behalf of the charity, and that anything that is partisan, make sure that if there's any views of a particular person, that it's separate from the charity and it's made clear that it's not the charity's view. Okay, so political activities. What exactly is political? So the CRA defines political activity as any public activity, so public is a key word there, that tries to change, retain, or oppose a law, decision, or policy of any government. Again, this is broad, and this is what sort of gives a lot of organizations pause. But as you'll come to see, is that at first blush, this is sounds all-encompassing, but there's significant room, and the CRA has carved advocacy and public awareness campaigns out of that definition of what is a political activity. So the CRA categorizes political activity into three general categories, which sort of narrows the scope of what is considered a political activity. So the first being a public call to action that puts pressure on a public official to change a law, policy, or decision of any government. So an example of a public call to action that would be a political activity would be organizing a march or a rally opposing Bill C-51, for example, which calls on the public to pressure their local MPs to vote a certain way. So that would be, that's the public call to action element, which is key to making that activity a political activity. The second category of political activity that the CRA considers a political activity is an explicit communication to the public that a change to law, policy, or decision should be made. So, for example, conducting well-reasoned research and publishing a report with specific recommendations on changes to the law based on the research that was conducted would be considered a political activity. Third is other action, so seemingly neutral public action where materials evidence the purpose of the activity is to change a law, policy, or decision of any government. And again, I just want to highlight that it's any government, not necessarily Canadian government. So this one, the third category here is a little more difficult to tease out, or anyhow, for me, it seems a little less intuitive. So as an example, an organization organizes a march to Parliament Hill to raise awareness on a findings that a large percentage of refugees to this country are without health care. So on its face, it may or may not be political, but the executive director's internal emails reveal, for example, that the march coincides with the debate to increase benefits to refugees, and that the purpose of the march was to exert pressure on the government. That would take it out of the category of public awareness campaign and into the political activity realm. Lastly, since the budget of 2012, political activities now include gifts to other qualified donees, which is defined under the Income Tax Act, which gift is intended to support the recipient's political activities. So gifts to other charities, so if a foundation, for example, makes a gift to a charity where it's reasonably considered that the purpose of the gift is to support that political activity, the foundation would have to count that donation as part of its own political activities. So another thing to be watched for here is that a qualified donee, most people think of it as charitable organizations. It does include a special subset of organizations that are not necessarily charitable, the UN being one of them. So that's just something to keep your mind, to keep in the background. So just have a quick sip of water here. Okay, so a charitable organization under the Income Tax Act is defined as an organization which devotes all of its resources to charitable activities. So there is a limited exception for political activities, which we just reviewed. So there are, though all the resources have to be devoted to charitable activities, Section 149.1 of the Income Tax Act carves out an exception to this and allows a certain amount of political activities to be undertaken by a charitable organization. And it sets out rules for that type, that political activity. So the first we've already discussed, political activity can't be partisan. So there can't be any linkages to any particular party or political candidate. The second part of the rule is that political activities must be ancillary and incidental to the charity's charitable mission. And third, substantially all of the resources must still be devoted to charitable activities. So we're going to sort of parse that out and what that means. Okay, so the 10% rule, that's that bit that substantially all of the resources must be devoted to charitable activities. That's called the 10% rule. So the Income Tax Act requires a charity to devote substantially all of its resources to its charitable purposes. The courts have held that that means 90% or more of its resources must be devoted to its charitable activities that directly go to furthering the mission of the charitable organization. So in other words, up to 10% of the resources of a charitable organization can then be devoted to political activities. So you might be wondering what we mean by resources when we're talking about 10% of the resources, 90% of resources. It's not actually a term that's defined in the Income Tax Act, but presumably it's broad and includes all of the charity's assets. So not just financial assets. You need to think of staff time, lease space, equipment. So all of the charity's assets are what I'm referring to when I'm talking about resources. So there's an exception to the 10% rule for smaller charities. So recognizing the constraint that the 10% rule places on small charities, the CRA's administrative guidelines have allowed small exceptions. So if the annual income of an organization is less than $50,000, it can in fact expend 20% of its resources on political activity. If it's between $50,000 and $100,000, in a charitable organization can expend 15% of its resources and still fall within the substantially all definition. And thirdly, if an organization's annual income is between $100,000 and $200,000, it can expend up to 12% of its resources on political activities. Okay, so the second rule for permissible political activities. All of the activities must be ancillary, the political activities, must be ancillary and subordinate to the charity's primary mission. So this really just is that the political activities can never become an end in and of itself. So that goes back to what we said in the very beginning, that the political activities can't become the mission of the organization. So of those permissible political activities which a charity can devote 10% of its resources to, those must be connected and subordinate to the purpose of the charity. So I prefer the terms connected and subordinate, which is, I think a little bit more understandable than ancillary and incidental. So I'm going to sort of sub those words in there. Ancillary and incidental are words that are used under the Income Tax Act. So incidental means that the political activity can never become the purpose or the goal of the charity. So it can't be the reason why the charity exists. Ancillary means that the political activity relates to or supports the purpose of the charity. So the issue that is the target of the political activity has to be an actual means of furthering the mission of the charity in itself. So as an example, so a charity that is formed for the relief of poverty by offering services for the settlement of refugees might make a call out to the public to write to local MPs to urge legislative reform to increase healthcare benefits for refugees. That's connected to its mission. Okay, so of the allowable political activity, just a few things to keep in mind. You'll need to keep track, all organizations must keep track of the political activity that they undertake. The resources that are expended on political activity now have to be reported with the charity's annual return in the T310 form, and keeping in mind that it does include gifts to qualified donees that are intended for political activity. So any gifts to other charitable organizations for their political work will need to be reported in that in the annual return of that charity. And then, of course, keeping in mind that substantially all resources is the 10% rule, so to a maximum of 10% of the charity's resources can be expended on political activity. Okay, so the third category of activities that the CRA sort of conceptualizes when talking about advocacy and political activities are charitable activities. So certain activities that appear at first glance to be political in nature are may be considered charitable by the CRA. So each of the types of activities that are listed on the slide we are looking at, so fostering public awareness about a charity's work or an issue related to a charity's work, private communications with an elected official, and public release of representations to government officials, all can be included, all can be considered charitable activities. So they don't get included in that 10% of resources that can be expended on political activities that need to be reported. So there's no cap on them in the way that there is with political activities. You might be sort of confused at first by the private communications with an elected official, but we'll get to why that's allowable. So this is what I mean, that there's lots of room, even though the definition of political activity, when we first went over it, seems sort of all-encompassing and broad, that there's still room for charities to undertake their work and participate in the public conversation about government policy. So in each of the cases of the permissible charitable activities here that we have listed, the activity must be well-reasoned and must not provide information that is false, inaccurate, or misleading. It must also be connected, as we said before, to the objects or the mission of the charity itself. And it cannot become the primary focus of the charitable organization. So let's talk first about public awareness campaigns. So what are public awareness campaigns? What does the CRA consider a public awareness campaign? They aim to give useful knowledge to the public to enable them to make decisions about the work a charity does or an issue that is related to an organization's work. So for example, distributing charities' research to the media or public or even all election candidates, where the research is well-reasoned and connected and subordinate to the charity's mission. So where it's perfectly charitable activity to conduct research on an issue that is related to the charity's overall mission and disseminate that research and its findings to the public at large. So the reason why that's acceptable, sort of going back through, you know, the limitations that we talked about, it's nonpartisan. So for example, it could be sent to all candidates. The findings could be sent to all candidates, so it would be nonpartisan. There's no explicit communication that a law or policy should be changed. So that being sort of a key component. There is no call to public action, that also being a key component. The research is well-reasoned and is connected and subordinate to its mission. So on that basis, it's a charitable activity and it's not limited in any way. So next, moving on to private communications with an elected official. that is considered charitable even where there's explicit communication to the elected official that a law or policy or decision ought to be retained, opposed, or changed. So an organization can make explicit representations that a law or policy should be changed or advocate for a change when it's done in private. So, for example, presenting research findings to a parliamentary standing committee, which at the end makes a specific recommendation on a change to a particular policy or law. So, for example, an organization that services immigrants and refugees might explicitly recommend increased healthcare funding for refugees to a standing committee, and that would be a charitable activity, which is not limited to that 10% that we talked about. So again, you can see where that sort of private versus public action is of importance there. Finally, the public release of representations to government officials. So an organization can actually release the same representations that it made in private to an elected official or a group of elected officials, so long as the entire text of the representation is produced and there is no call to action. So again, that call to action component coming up. So a charitable organization, after, let's say we'll use that same organization we were just talking about, that provides services to immigrants and refugees, has presented its findings on a study to a standing committee, a parliamentary standing committee, and recommended an increase to healthcare spending for refugees. They may then, as a press release, include the text, the entire text of that representation and who it was made to, so long as within that text and the context in which it's released, there is no public call to action to pressure, to have the public pressure their MPs, and that there's no, let's say, internal communication that says, the purpose that we're publishing this is to exert pressure. So those are all activities that are charitable and therefore certainly permissible and are not limited to 10% of the resources. Okay, so this is, and I'm sorry that it might not be so legible on this small slide. So I've said that I will have this put into an entire PDF, which I'll provide to Ocasio, and they can disseminate as sort of like a summary of our discussion today. And it's a useful flow chart to use as a framework for analyzing certain activities to determine whether they're permissible, whether they're political activity that needs to be reported, or whether, in fact, they're charitable activity. So I won't take you through every element of that, but just quickly we'll sort of revisit a few of the topics. So one, sort of when you're teasing out, or I find anyhow, the difficulty when thinking about this is teasing out advocacy and public awareness campaigns, let's say, from activity that is political in nature. So the key components, and I just want to touch briefly back on them, being that if there's a public call to action, so calling people to act, to pressure, to put pressure on public officials to act a certain way or to change a law or policy, then we're talking about something that is political. So if there is no public call to action, then perhaps it's a charitable activity. Where there is an explicit recommendation made publicly by a charitable organization that a law, policy, or decision of the government should be changed, then if we're talking about, again, the keyword being an explicit recommendation, we're sort of back into the realm of political activity as opposed to public awareness, which is a charitable activity. Any activity must be nonpartisan, so that is a prohibited activity. So any connection to any candidate or political party is a no-go, and as soon as you consider that there might be a link to a political candidate or a favoritism shown to a political party by, again, going back to our example where you might allow a particular candidate which has, if you've invited an all-party debate, for example, more time to speak, then that could be seen as favoritism and could be seen as partisan. And lastly, private representations give more latitude to make recommendations on changes to laws and policy, because those private representations to government officials are considered charitable, and will be so long as they're well reasoned and of course based on not based on any misleading information. So that gives a lot of latitude to organizations to advocate for their mission and certain changes. So that's a summary of the very broad principles that we talked about here today. Some of the resources that you might find helpful in sort of teasing these concepts out a little bit more, or to just sort of look a little further into. The CRA policy, you'll see the bottom bullet point there, CPS 023 policy statement. That is the policy statement. I'm sorry, the second bullet point, CPS 022. That is the policy statement on political activities. It's long, but it has a lot of great examples if you find that you're still sort of struggling through these concepts. So I would recommend taking a look through that if you want to explore this a little further. And on that note, we can go to a few questions. Sure. Awesome. Okay. So maybe should I start at the top with the older questions?
No, those are the technical
Oh,
ones.
okay. Okay.
Maybe you could read out the questions.
Sure. I have a question here. Lauren, is 10% based solely on money and resources spent? Does it include staff time? Would this be 10% out of all our staff hours, or could it be on staff's time? So you need to think of the 10% as being, broader than a pot of money. So it would include, for example, staff time and the resources. So if you're devoting 10% of the hours of your staff time to a particular political activity, that gets thrown into the 10% of all of your resources. So it's you can monetize it in that way. So it's or could it be one's? Would this be 10% of out of all staff hours, or could it be one's staff's time? Yes, it could be staff's time. So you have to think of it more as like a qualitative assessment there. So 10% of all your staff time, if you're devoting it to a particular political activity, that's the way you would sort of report that and think about that. So it's not just money spent or on, let's say, taking out the newspaper ads that for your cause. So you need to think about it as hours and time that staff devote to it as well. On this question? Oh, okay. To this?
So does anyone have their hand up? Because I see the hand up icon, but don't really. Oh, yes. Okay. So we have Paula's hand up and Isa. Paula and Isa, for this webinar, we are asking people to type in their questions because of the challenges we had with the mics the last time. So if you have a question, people, please type it into the pane and Lauren will read it out and answer the question. So while we're waiting for you to type in a question, I'm going to ask one question that has come up, which is member agencies are often asked by government to participate in consultations. So, for example, in Ontario right now, there's a consultation on the Changing Workplaces Review. So when we participate in consultations like that and we have an explicit recommendation about a policy or a law, would that be considered political activity?
No, so a consultation like that, when you're asked to take part, it sort of falls under that private representation, and when you're making a recommendation to a public official on a certain change. So that would be a charitable activity, which is not restricted by that doesn't need to be reported in the 10% of political activities. Okay, could you expand on the private communications with an elected or public official? I think that's, we just sort of did. Okay, there's more to this, Paula. If an employee...
So that's a different question. That's a different question.
Oh, that's, oh, I'm sorry. Oh, sorry, that's a different question. Could you expand on the private communications with elected or public official? I think, you know, it's that... So long as it's not, so long as you're not making sort of a public sort of plea for a change to a law or policy, it's done in private with, it could be, it doesn't have to be just one public official, a group of public officials. So for example, if you're asked to sit on an advisory committee, that is a charitable activity where it is well-reasoned, and where it's based on, not based on any kind of incorrect information or misleading information. And so long as that takes place in a private context, that's considered a charitable activity. Okay. So if an employee participates in a political demonstration and they do not state they are representing their organization, can this come back to harm the organization, especially if the media is present? Again, you know, staff of an organization, employees are free to express their political views. Certainly they can participate in a political demonstration. So long as they're not wearing the stripes of the organization at that event, there's no reason to consider them as acting in any other capacity other than their personal capacity. So it's fine for an employee to participate in a march, for example, or any kind of political demonstration, so long as they don't explicitly state that they're representing the views of the charity. So that's, it's not simply going to be implied as the views of the charity just because a staff member is present at a political demonstration. Okay, in the last table or chart, should the so actually let me just go back to it so people, can they go back?
I'm not, I don't think so.
Okay, so I'll go back.
We went through these questions.
Okay. So, so we can all look at what we're talking about here. Okay. In the last table chart, should the stop sign be interpreted as consider the 10% rule? Even if it's a political activity, up to 10% of resources of a charitable organization can still be devoted to political purposes. So, so what's the stop signs here I think you're referring to the one on the far, it'll be the far right of your screen. It says, does the activity involve supporting or opposing a particular party, politician, or candidate for political office? The reason why it says stop there is because that is considered a partisan activity. So if it's supporting a particular political party, if it's supporting a particular or opposing a particular political candidate, that's considered a partisan political activity, and that is not permissible. So no, the 10% rule does not apply to that. So any partisan activity should not be undertaken by a charitable organization. If an organization is perceived as linking itself with a political candidate by endorsing one, for example, then it risks losing its charitable status. Okay, so can an employee actively participate in politics outside of Canada? Again, so long as the employee is acting in their personal capacity and they're not wearing the stripes of the charitable organization or making representations that in fact they're acting on behalf of the charitable organization, then of course they're free to participate in political activity outside of Canada. I'm sorry, Tina, I'm not sure I understand the last question. It reads, is 10% down to the tokens we give out to get to a demo?
I'm assuming that's public transit tokens, so TTC tokens in Toronto, perhaps.
And sorry, is the concern there?
So I'm assuming the question is that if the organization gives clients bus tickets to get to a demonstration, would that be considered part of the 10%?
Oh, I see. If it's giving 10% of its it's giving out tokens to its participants to attend a demonstration, it's probably part of, yes, its political activity. Again, so long as this isn't, for example, if it wasn't connected to any kind of partisan activity, it would be permissible as political activity. So if a political party contacts a charity to speak to an event or participate in an event, and the charity says yes, will the charity be penalized? The political party contacts a charity to speak to an event. Again, so this comes down to the partisan rule. So if a charitable organization is seen at an event as having a linkage, I mean, if it's endorsing that candidate or endorsing the party, then it would not be permissible. So it has to be careful of that endorsement or opposition part, and so it would have to be careful about its messaging there.
So could I perhaps expand on that question?
Sure.
Because we have been in this situation where recently, and I'll name the party, well, one of the major political parties at the federal level organized community events in a particular riding, and they invited the community organizations that were serving immigrants and refugees in that riding to be part of an information fair that was also part of clearly a political event. And those organizations participated because, so they set up information tables and booths, and all they were speaking to were their services. Would that be considered political activity?
That's an interesting one. And you said it was clearly otherwise a political event. It was promoting a particular candidate.
It was, well, it was not during the election call, so it was before the election call, but it was organized by the party in the name of the party, and it was profiling the candidate who also happened to be the MP. So the person was already elected as an MP, was sitting in Parliament, and was, you know, the representative of the people who lived in the riding.
So I think, you know, truthfully, I'd have to think about that one a little bit more. Certainly the messaging is not the issue there in terms of public awareness and sort of the work that the organization does and disseminating information about the issue, but whether Again, it can be seen as endorsing a political candidate in that case, or a particular political party. I'd have to think about that one a little bit more. I'm sorry, I can't give you a definitive answer off the bat there.
Okay, fair enough.
What if we invite all the candidates but only one shows up? Is this seen as partisan? Again, this is an answer I think I'm not sure that there's a clear answer off the bat. I do think I need to think about that a little bit more, but I think probably the answer is that so long as all the candidates were invited, and it's clear that all were invited, and we're going to be given an opportunity, a fair opportunity to speak, then probably it's a political activity. But I would want to get advice on that before pursuing that. Okay, so this question, so how serious is it if a charity is found to be participating in political activity? What are the repercussions? I want to stress that a charitable organization can undertake political activity. So we talked about permissible political activity. There's just constraints on how much political activity. So partisan activity, where you're endorsing a particular candidate or opposing a particular candidate or party, is never allowed. Political activity, so public calls to action for a this is just one example, a public call to action to pressure your MP to oppose Bill C-51. So a charity puts out a call to all its members to write, and even provides a template to write to their local MP to put pressure on them. That is an allowable political activity. There's nothing, illegal per se about that. However, a charitable organization has to make sure that it fits within the rules that apply to political activity. So that being that it's not expending more than 10% of its resources on that activity. So in that year, would putting that for a small charity, a very small charity, it could be that activity, putting together that letter, putting a call out to its participants to pressure its MPs, is actually 10% or close to 10% of its political activities, allowable political activities. So that might be all of the political activities that they're able to undertake that year. So I want to be very clear that political activity is allowed. So clear, activity that's targeted at changing or opposing or retaining a law or policy is allowed. It's just subject to certain constraints, one of them being the 10% rule. In terms of how serious it is, if a charity is found to be participating in partisan politics, it's very serious. So if a charity endorses Tom Mulcair, for example, it could lose its charitable status, so it's serious. Okay, the last question. We have our local MP and MPP come to hand out certificates to volunteer. This is fine, question mark. I would be very careful about that. If you're the organization could be seen in this case to be participating in partisan activities. So I would caution you against your organization against that activity. I think that's all the questions we have time for. So thanks very much for having me here today, and really great questions. So thank you very much.